Welcome to the definitive explainer on mastering India's alternative dispute resolution ecosystem. Look, if you want to navigate the dense, incredibly high-stakes terrain of modern justice without getting completely bogged down in literally years of litigation, you are in the exact right place. We're going to decode the statutes, break down the absolute landmark case laws, and hand you the tactical knowledge to understand how massive disputes are actually settled today. So, here's our roadmap for this explainer. 1. Why we need ADR. 2. Defining the ADR landscape. 3. The Arbitration and Conciliation Act. 4. Landmark arbitration case laws. And finally, number 5, mediation and the wider ADR ecosystem. Let's dive right in. Section 1. Why we need ADR. Okay, to understand the cure, we first have to understand the sheer magnitude of the disease. 4.5 crore. Just let that staggering number sink in for a second. As of 2024, over 4.5 crore cases are currently pending in Indian courts. I mean, we're talking about decades of delays, absolutely exorbitant opportunity costs, and entirely destroyed business relationships just locked up in an adversarial courtroom. It's not just a backlog anymore. It is a total gridlock. And this undeniable reality, well, that's exactly what makes our solution an absolute necessity. And that brings us to the real power of ADR. This is how you completely bypass that exhausted traditional system. ADR guarantees confidentiality, right? So your private disputes aren't just aired out in public. But the absolutely crucial pillars here are party autonomy and the finality of awards. You get to shape the procedure. You pick a highly specialized technical expert to decide your specific commercial dispute. And once that award drops, the grounds to challenge it are incredibly narrow. It's fast and it is final. Section 2. Defining the ADR landscape. Right, before we get into the heavy legal machinery, we really need to map out our options. ADR basically falls into 3 buckets. Unilateral is just your internal grievance redressal. Bilateral is just you and the other party negotiating directly. But our focus today is triadic ADR. This is where a neutral third party actually steps into the arena with you, like mediation, conciliation, and arbitration. They're either there to assist you both or to make the final call. Now, there is a sharp, fundamental contrast you absolutely cannot afford to mix up: arbitration versus conciliation. In arbitration, the arbitral tribunal decides the dispute. They hear the arguments and they drop a binding and forcible award, period. In conciliation, on the other hand, the conciliator simply facilitates a settlement. They guide you, sure, but that settlement only becomes binding if both parties actually agree to sign it. Huge difference. But what about mediation versus conciliation? Now, in India, these terms get thrown around interchangeably all the time. But legally speaking, there's a strict nuance. A mediator is generally passive. They facilitate the discussion to help the parties find common ground on their own. A conciliator, though, is highly proactive. They evaluate the case and can directly suggest actual solutions to the parties. Moving on to Section 3, the Arbitration and Conciliation Act. We are looking at the absolute primary engine of Indian ADR. The 1996 Act originally consolidated a bunch of outdated laws to align India globally. But, it wasn't perfect. In 2015, a massive amendment dropped a strict 12-month time limit for awards and heavily restricted court interference. Then in 2019, the Arbitration Council of India was created to really push institutional arbitration. And finally, in 2021, the law was tightened even further to allow automatic stays on awards only if there's prima facie evidence of fraud. Notice the pattern? Every single step has been about increasing speed and keeping the traditional courts out of it. So how do you actually start the whole thing? Well, Section 11 dictates the appointment of an arbitrator. Think of it as a sequential chain reaction. Party A appoints their arbitrator, Party B appoints theirs, then those 2 arbitrators get together and jointly appoint a third person who acts as the presiding arbitrator. But if this chain breaks down, say an agreement fails within 30 days, the courts step in. For domestic arbitration, the High Court appoints. For international commercial arbitration, it goes straight up to the Supreme Court. Okay, pay close attention to this next part because this is where massive corporations make fatal legal mistakes. The difference between seat and venue. Listen, the venue is literally just the physical room where you hold the hearings. It means absolutely nothing legally. The seat of arbitration, however, is your critical legal anchor. It determines which country's choreal law, meaning the specific procedural framework, actually governs the entire process. Setting the seat dictates everything, which perfectly sets up our first major high-stakes case law. Section 4.
landmark arbitration case laws.
Lock in right now for this one. First up is the epic 2012 Battle of Balco versus Kaiser Aluminum. Basically, an Indian and a U.S. company had an agreement with a London seat, but the Indian party tried to get interim relief in an Indian court. So the core issue was, does Part 1 of the Act, which gives Indian courts the power to interfere, apply if the seat is outside India? Well, a massive 5-judge constitution bench delivered a definitive ruling no. Part 1 applies only to arbitrations seated in India. If your seat is foreign, Indian courts have absolutely zero jurisdiction until the very end when it comes to enforcement. It was a completely monumental shift that overruled previous precedent.
Next up, ONGC versus Saw Pipes Ltd. in 2003. Now, this one is heavy. Under Section 34, you can only set aside an award on very limited grounds, like it conflicting with the public policy of India. Well, the Supreme Court completely blew the doors wide open here. They introduced the patent illegality doctrine. They ruled that if an award is manifestly contrary to the substantive law of India, it actually violates public policy and can be set aside. Overnight, arbitration awards suddenly became highly vulnerable to court interference. And that brilliantly illustrates the intense tug-of-war between the courts and the legislature. Because that sweeping patent illegality standard from saw pipes, it caused absolute chaos and led to endless appeals. So the legislature launched a massive counterstrike. The 2015 amendment pushed back hard, reeling in that incredibly broad definition. It tightened Section 34, making it absolutely clear that violating public policy strictly means fraud, corruption, or violating fundamental morality. Just like that, the finality of domestic arbitration was fiercely protected once again. Section 5. Mediation and the wider ADR ecosystem.
All right, we've talked a lot about high-stakes corporate arbitration. Now, let's broaden the lens a bit. Enter the loc et alats, or the People's Court. These forums handle pending civil matters and, crucially, compoundable cases, meaning offenses where the law legally allows the parties to just compromise and drop the charges. They operate in a highly informal manner, but do not mistake informal for powerless. Once a compromise is reached, a loc et alat award carries the exact binding weight of a civil court decree. It is completely enforceable, and there is absolutely no path for appeal. Now, how do the actual courts integrate this? Look no further than Salem Advocate Bar Association versus Union of India back in 2005. So Section 89 of the Civil Procedure Code made ADR reference mandatory, but the courts honestly just didn't know how to implement it. The Supreme Court stepped in and literally institutionalized court-annexed ADR. They ruled that Section 89 mandates ADR consideration at the very first stage of a lawsuit. They ordered the creation of strict ADR rules, trained mediators, and dedicated ADR centers built right inside the court complexes. Which brings us to the absolute bleeding edge of ADR law today, the Mediation Act 2023. Guys, this is a real game changer. It elevates mediation from a soft alternative chat to a rock-solid legal framework. It ensures complete confidentiality. It makes mediated settlement agreements, or MSAs, directly enforceable as actual court decrees. It expressly legalizes online mediation, sets up the Mediation Council of India to regulate the entire space, and it heavily incentivizes settling disputes before a lawsuit is even filed. As the quote goes, justice is no longer confined to the adversarial courtroom. It is actively forged at the collaborative table. We really have moved from a system of endless legal warfare to one of highly strategic resolution. So I want to leave you with this final provocative thought. If a collaborative settlement table can yield the exact same binding power as a traditional civil court decree, saving literally years of time and millions in costs, is traditional litigation rapidly becoming obsolete? Thank you for checking out this definitive ADR explainer. Keep analyzing, stay sharp, and I'll catch you in the next one.